We do have time for questions, and so let's do this. Any of the panelists who want to answer a question, please do, but you can direct a question specifically to either Richard, Tom, or Sarah. And the only thing I would just ask is if the panelists could just repeat the question, that would be great.
And I'm going to paraphrase that significantly. But that how soon will foreign national spouses who've applied for adjustment of status be able to get employment authorization based upon having a pending application for adjustment? Have any families received employment authorization since this decision, and how soon can we expect that they will? First, I'd say there are families actually getting green cards now. And so, I mean, it's just a drip, drip, drip before I think the faucet opens up. But were families who filed sort of, even before the Supreme Court's decision, and that wasn't the right. Don't feel like you missed the boat there, because that was a really hard go of it. They were definitely swimming upstream, but for some families they were between a rock and a hard place, and it made sense to do something bold. We're seeing some of those families starting to get actual their green card, their legal permanent residency, and so they, as a resident, have the ability to work. With temporary employment authorization, I think there's every reason to expect that the rule is the rule, and being gay has nothing to do with it anymore. And so for people who've applied for adjustment of status since the Supreme Court's decision, I think they should expect that they will be given temporary employment authorization within 90 days. At 90 days. And there's a process by which if you don't have your green card in your pocket, and you won't, after 90 days, there are a couple of different processes by which you can call them up or go to the office with an appointment and say, hey, where's my temporary work authorization, and get that. So I do think that the general rule of 90 days is what we expect will be the experience for same-sex binational couples as well.
So in the context, this is probably going to be a speculative answer, but if you have someone who is currently applying for some other sort of visa, but is also a same-sex spouse, is it advantageous for them to withdraw that application and put in, if they're in one of these long waiting lines, right, because there are current numbers available to apply for like a spouse visa? Do you think, is that a case-by-case question, or does it make sense to...
Generally, you can have parallel applications pending.
Okay.
So the normal rule, it needs to be looked at carefully in each case, but the normal rule would be file whatever you want and see which comes up first, presuming they're not contradicting one another, and most of the time they wouldn't. So you could have an employment-based case pending and then file an application for permanent residence based on the spousal petition. And depending upon the category of the employment-based case, the spousal one may come up faster, very often will. So one doesn't exclude the other. On the other hand, if you're very close to getting residence through the employment-based case, filing another case and spending all that money is probably a big waste of time. Also, if you're getting employment through, permanent residence through an employment-based case, but you're married to a U.S. citizen, you get the benefit of being able to become a naturalized citizen in 3 years because you're married, even though your wife doesn't sponsor you. So you don't have to be pushed towards the marriage side of it. You'll still get the better of both. And if it's a new marriage that is less than 2 years old, what you get is conditional residence, it's conditional permanent residence. It's good for only 2 years, and at the end of it, you have to apply again to show that it really is a good marriage, in effect. And then they remove the conditions and grant straight permanent residence, bad word, but permanent residence, then unconditional permanent residence. So if you were to get permanent residence through your job, you wouldn't get conditional permanent residence, you'd just get unconditional permanent residence. And you would get this fast process towards naturalization, towards citizenship, even though you didn't get the green card from your wife. So overall, you need to look at it carefully and make sure you're not wasting money, because you may get it better through what's pending.
One other thing I'd want to add there is, another thing to consider is if the visa that they're applying for now is a non-immigrant visa, there are certain non-immigrant visas that allow you to have immigrant intent. So like if your partner's applying for an H-1B and you think, oh, I should get that quicker and she could be here and she could be working, and then we start the spouse petition. Okay, but if, say, a partner's applying for a student visa or a tourist visa, there's a number of non-immigrant visas that don't allow you to have the intention to stay. And so in certain of those instances, getting married and submitting a spouse petition might sort of jettison the ability of the foreign national partner to get some sort of interim status to come. So if they're scheduled to start here at school in the fall, you might make a decision to put off submitting an immigrant petition, if they really wanted to go to school and this just wasn't like a wait for DOMA to die plan. You should talk about it with counsel to figure out whether in any way those two applications or petitions would interfere with each other. The other thing I'd say, Richard brought up a really good point about sort of conditional residency for newlyweds. The one thing that we've asked for additional guidance on, and I think we're going to get the right decision from DHS and the State Department, is when are we counting that marriage from? We have every expectation, and we've pushed strongly for them to count it from when you got married, not from the Windsor decision, right? So if you were married in Massachusetts in 2004, you've been married since 2004. You haven't been married just since June 26th, right? So when you're counting that conditional residency period, it's our expectation that you'll get full credit for the time that you've been hitched.
The question is whether or not it's advantageous to get married in effect in two countries where marriage is allowed. And more specifically, it was if a Canadian were to marry in Canada and then come back into the United States as a student, would there be issues? So the second part first, there are issues. That's what Tom was talking about. The F1, which is the student visa, says that you have to have an intent to return home. So they call it a non-immigrant or temporary intent. Marriage to a U.S. citizen is one strong indicator to the officer that you may have changed your intent and that there's something else going on. So, when they wouldn't recognize our marriages, a lot of attorneys, including myself, said, on the form, I think you can say, honestly, I'm not married. If you're saying I can't get anything for being married, you won't recognize my marriage, you won't accept my tax return if I'm married, then on the application for a non-immigrant visa, you should be able to say I'm not married. Some people said, no, I will say it. Some said, I'll say not married, but I'll drop an asterisk and a footnote. That's all gone. Now you have to say honestly on that application. Now, Canadians don't have to get visas usually, so it's different for Canadians. But from most other countries in the world, you'd have to get a visa. You have to fill out that form, indicate that you're married. If you're married in a country that it recognizes same-sex marriage, we're going to recognize it almost certainly. And yeah, that'll bring up a whole line of questioning from the consular officer. In terms of getting married in two countries, I can't see any reason why you'd want to do that.
So the question was, Tom, you said we should get an attorney, and there are a lot of people who can't afford legal services. Is your concern about them having representation sort of the newness of this experience for same-sex binational couples and the lack of guidance available right now? After a period of time, would you be less concerned about people doing it on their own? If a straight couple came to me and asked me, do I need an attorney? I would, in most instances, say yes. There are forms and really great instructions on USCIS's webpage, but it's a bit of a minefield on issues that if you're doing it for the first time, you might not know to look for. And so it's not that we're rocket scientists, but it's just that this won't be our first petition, right? It's not our first time at the rodeo. And so I think if you work with someone who's thought through these issues, they're looking for red flags, like are there any concerns here? They're asking you the right questions. I think that if you can afford counsel, it makes sense to get counsel. And again, there are many organizations, community-based organizations that provide free or low-cost immigration representation. And so if that's the circumstance for a given individual, they can also reach out to us and we'll try to provide them with referrals in their area for legal services. So how do we get the word out to make sure that people get the right answer to their questions and aren't sort of guided by misinformation? Our website, probably my executive director would have been excited about me announcing this, but our website went down for about a minute on the day of the Windsor decision because we went from 5 people on the website to 50,000 people just coming into the website trying to figure out what this meant. And so there definitely are, I think, there's trusted advisors in our communities, and we're not the only one. Immigration Equality partnered with a number of sort of our trusted allies in the LGBT, civil rights movement, including GLAAD and the ACLU and the National Center for Lesbian Rights, and Lambda Legal and others in putting together sort of a comprehensive guide on what the Windsor decision means in a number of areas of law. And that document is also hosted on all of our websites. And so while the content of our website is really focused on immigration issues, I do hope that that sort of collaboration will give multiple points of entry. And then the other thing is really reaching out to immigration practitioners and ones that we trust and know, but also we're trying to get the word out to the larger sort of legal community about what these issues mean. And then I think events like this that are just points of contact with communities that are affected. But it's a very valid concern and something that we're going to have to continue to work at.
So the question is, what happens if when you apply for residence and it's granted, you've already been married for more than 2 years? Then you would not be granted conditional permanent residence, you'd be granted just permanent residence. The green card that comes is for 10 years, but the residence is for the life, as long as the person maintains it. So you don't have to go through removal of conditions. You just can remain here as a resident. If you remain married and living with the U.S. citizen spouse, you can then apply for citizenship if you choose 3 years later.
But does that also create complications if the spouse has come here on a tourist visa, for example? Because,
You mean you were married abroad and then
you've been here several times since, on a tourist visa, which means...
It'll raise those same issues. That 30, 60, 90-day rule that we're talking about is whether a marriage takes place or an application for residence within 30 days after arrival, or 30 to 60. So you want to think that through very carefully, or you may turn a simple case into a complicated one.
And we have raised the issue of many of our families have been married for years and years and years, sometimes decades, and have had to use student visas or tourist visas, and some of us didn't have access to those. And so we definitely have raised the issue that Richard sort of touched upon, in that many families would not list married as their marital status on immigration forms, or if asked about, who are you staying with, what's the purpose of your visit, would dance around the fact that I'm in love with an American wasn't the best lead on to those questions. And so we've really talked about, there are going to be, for some families, instances where they maybe went into secondary questioning at a point of entry and answered some questions and that might have teetered on a material misstatement of fact. And we've really just asked the agency to understand the circumstances under which those statements were made, and to be generous in their interpretation of those statements. So, but otherwise, I think he's right.
Thank you all so much for doing all the work, as Tom said, for so long in this area. I remember the very week of the Windsor decision, I had to go do a panel on DOMA, and there was someone who came up to me afterwards and said, my spouse's visa is going to expire next week. And so we are going to be watching Thursday on the US Supreme Court's website, and it's either going to be pop the champagne or we have to look for plane tickets. And so for that couple and for all of you, just congratulations.